Hello, everyone. Welcome to the Illinois State Bar Association's Illinois Law. And we are going to discuss today healthcare reform. And we are very privileged to have two very distinguished guests on the show today. To my far right is Mark Mosby. And Mark is a healthcare attorney licensed in both Illinois and Michigan, and a member of the Illinois State Bar Association's Healthcare Section Council. Currently, he is the director of the legal department of Priority Health, a Michigan-based health plan. He has spent the majority of his 25-year career as an in-house attorney for health insurance companies and health benefit administrators. And to my closer right is Nancy McKenna. And she's an attorney who has been practicing healthcare law for the past 16 years and previously was a nurse in healthcare for many years. She represents hospitals and physicians and is an assistant professor at the University of St. Francis, teaching healthcare law and healthcare policy. So welcome. I appreciate the two of you being here today to talk about a topic that's on the minds of many. And I'd like to get started with the conversation with you, Mark, first by discussing one of the principal goals of the federal health care reform we understand is to expand health insurance coverage to more Americans. Now, many Americans, for example, work for small businesses that don't often offer health insurance. So let me know, do you have any indication as yet whether more small businesses are now able to or will be providing health insurance under this health reform legislation?
Thank you, Latham. We are getting some early evidence that more and more small businesses are choosing to cover their employees, and as a result of federal health care reform, one of the what I'll call early reforms included for 2010 a tax credit that is directed at what we call small employers or small businesses with 25 or fewer employees, and that will those employers who choose to take advantage of the tax credit, and again, it's very targeted at what we would normally characterize as small businesses. But that allows the small employer to contribute, or rather to receive a tax credit, the maximum of which is 35% of whatever that employer is contributing to the health care coverage of its employees. So what the early indications are, so we've just passed the 1-year mark with health care reform, is that we have approximately 4 million small employers in this country that can or have, some who have taken advantage of this tax credit, and it's a bit anecdotal right now as to exactly the numbers of additional employers that are taking advantage of this tax credit and extending coverage to more and more employees, but we've seen in certain markets in various parts of the country, very large employers, or rather large insurance carriers, that are indicating that there's some considerable uptick in the number of employers that have come to them saying, we want additional coverage or for our small employee segment. So one of the aspects to qualify for this tax credit for small employers is that they have already been providing at least 50% of the coverage for their employees. And as I said, it's really targeted to at least to maximize that tax credit to really the smallest of businesses, but I think it's still pretty meaningful. And so we've seen a real uptick in since the enactment, and I think it's encouraging more small businesses to encourage or to extend coverage as well. And so this will lead up to a ramp-up period to 2014 when small employers can participate on the healthcare exchanges.
And we'll talk about what is a healthcare exchange, but let me ask a couple of follow-up questions. One is there a general definition of what's a small business?
Yes. For purposes of this tax credit, as I mentioned, it really targets businesses with 25 or fewer employees who pay an average wage that doesn't exceed $50,000 per employee. But for purposes of healthcare reform as a whole, and I had mentioned the exchanges, but that will really include, as far as the definition of small employee, employers that have 100 or fewer employees. And then states, by definition, have defined small employers typically to include 50 or fewer or 25 or fewer, depending on the state. So you have this mix of definitions for small employer.
And the second related question is, what are the benefit packages look like that they're able to offer under their insurance? Is it comparable to the larger insurance, or do you tend to find more deductibles, more co-insurance? What does it look like that, I recognize, given their size, their ability to afford something as complex or as rich as maybe some of the larger employees is probably not there. But can you have a general idea of what the benefit packages look like?
Those benefit packages are really, and again, this is in part the result of healthcare reform, those benefit packages have to reflect the reforms that are already in place. So there have been a number of what we call insurance market reforms that became effective 6 months after the enactment of healthcare reform. So, and as we lead up to this period leading up to 2014, and then once we get to 2014 and we have a definition of essential benefits, then these packages will really they won't be different in any significant way to what would be available or is available to the large employer market.
Now, we're going to ask Nancy in the second part of the program to talk about what is on my mind, and that is the whole constitutionality of healthcare reform. But let's assuming it passes mustard, or we'll save that conversation and get Nancy's thoughts. But tell me more about this thing that you were referring to. I asked you to hold on to in terms of the structure. What is this?
Currently, there's a lot of preparation on the part of healthcare insurers and to prepare, in states, to prepare for what we call the state-run healthcare exchanges. And what the exchange will allow both individuals and small employers to do is to go to the online marketplace, and we will see variations among the states that will have oversight of these healthcare exchanges. But it will create a marketplace where a consumer, an individual, or small employer can compare health benefit coverages, can compare insurers. It'll give a level of transparency that we don't have currently in the system. And these exchanges will be required to allow insurers to compete in that marketplace, but they'll also require that that consumers and small employers have essential benefits. And so we have some experience with state exchanges already. The Commonwealth of Massachusetts has had an exchange for several years now, which involves a lot of government oversight of that exchange. In contrast, the state of Utah has one where basically individuals can go on a website and see what carriers are participating on the exchange, but there's not a lot of regulation of rates or prices or those sorts of things.
Wasn't there once a proposal for the government to have an option to?
Yes,
Yeah,
that
what
was
happened to that?
That was the public option, and that was subject to a considerable degree of debate during the entire ramp up to the enactment of health care reform. And there was a genuine concern on the part of the private payers, the health care insurers, that if you permit a public option, that could really reduce the potential market to the private insurers. And as we're looking forward to 2014, when we have the start of these exchanges at the state levels, we're going to see a flood, an influx of millions of more insureds, in part because of the individual mandate, obviously, to mandate coverages. And so there was a concern with a public option that it would kind of crowd out, and consumers, individuals particularly, and small, would gravitate to the public option and shrink the pool for the health insurers.
And it's 2014 when we think we'll see it more in full bloom, correct?
Yeah, there's a lot of work being done now, even in Illinois, with the Healthcare Reform Council, to prepare for the exchanges. Some states are opposed to the exchanges. If a state chooses to opt out, the federal government will run the exchange.
So when we come back, we will talk about, is all of this stuff constitutional? Is it legal? And we have Nancy McKenna, who will guide us through that. I think it's a lot of interesting questions about, can we have this whole structure that people are interested in seeing us, some are interested in seeing us develop. So we'll be right back, and we will talk more about the constitutionality. Nancy, look forward to your comments on that.
Bye-bye, Tyler.
Bye-bye, Tyler.
Dear, it's time for serious talk.
Oh?
About my daycare. When I started out, it was just to help the neighbors. But lately, it's getting to be a real handful. I need some help.
What can I do?
I need advice on more space, a loan,
What about incorporating?
and insurance.
Wait, I know who we can call.
Times like this require sound advice. Your lawyer can help. A message from the Illinois State Bar Association. Over and over. Time and again.
Drive me nuts. Shut up. You're the dumbest.
Generation after generation.
I hate you. I hate you too.
Isn't it time we stop the cycle? Now.
I hate you. I hate you.
Stop adult violence. Teach kids peace. A message from the Illinois State Bar Association.
Welcome back. My name is Latham Williams. I'm your host, and this is the Illinois State Bar Association's Illinois Law. Our topic today is that boring, non-controversial topic of healthcare reform. We are fortunate today to have two splendid experts in the area who are giving us some understanding and clarification on the topic. Mark Mosby, who is a healthcare attorney licensed in both Illinois and Michigan, who's a member of the Illinois State Bar Association's Healthcare Section Council, and he's currently the director of the legal department of Priority Health, the Michigan-based healthcare plan, is with us. And we have, I should say, Professor McKenna, who is an attorney. It's been practicing healthcare for the past 16 years. She was previously a nurse in healthcare for many years. She represents the healthcare professionals and healthcare institutions. I'd like to turn the conversation towards Professor McKenna, Nancy, because I think there is a lot of anxiety in our society as to whether this reform is going to make it through. There are those who are getting away from the politics of those who want it and those who do want it. I think there's great uncertainty as to what it's going to, whether it will make it, and if it does make it, what will it look like. Well, maybe you can just give our viewers a general landscape or general understanding of what are the questions and what are the challenges ahead.
Well, essentially, when Congress enacted the healthcare reform law, the various statutes that are collectively called healthcare reform, they acted under two powers under our U.S. Constitution. Under Article 1, first being the General Welfare Clause, which allows the Congress to tax. And the U.S. government is stating that the healthcare reform law is a tax, and Congress has the power to do this under the General Welfare Clause. The other aspect of it, under Article 1 of the U.S. Constitution, is under the Commerce Clause, which allows Congress to regulate commerce between the states. And the concern and the challenge and the critics of healthcare reform, and it's been challenged by at least 24 states in the federal court system and the district courts, essentially is that that it's not a tax. And what they did when they enacted the law, they amended the Illinois or the Internal Revenue Code to assess a penalty if individuals do not purchase the insurance on the state insurance exchanges. And uniformly thus far, the challenge of this law being a tax has been consistently upheld that it's not a tax. So the other issue is that it's likely that the challenge and the decision that's going to be made is...
And before you go into that, talk a little bit more about why it's not a tax. You did say uniformly the courts seem to get that one clear.
Yes.
Yeah. What is it that would have made it a tax, and why is it not a tax? What are some of the characteristics?
Well, the U.S. government still holds the position that it is a tax, but the courts have assessed the law in terms of what historically has been a tax, and they feel that just amending the Internal Revenue Code and assessing a penalty is not enough. There's also the Anti-Injunction Act, which prohibits people from challenging taxes and prohibits people from getting an injunction against the tax. The issue with other taxes that this law doesn't have is that you can, if you don't pay your tax, there's criminal penalties. You could go to jail. You could have a lien put against your property. This penalty doesn't have those provisions as all other taxes do. So the courts, when it's been challenged, have consistently felt that under the General Welfare Clause and under the case law in relation to taxes, that it really is not a tax.
So the tax argument sounds like it's not going anywhere.
Right.
So tell us about the one that's creating the split in what they call the districts or the circuits. And you may need to tell us what is a district in your conversation.
In our jurisprudence and in our legal system here in the United States, when there is a question regarding the U.S. Constitution or a federal question, or there is a difference among the lower federal court, which are the district courts, then it has to be appealed. and the United States Supreme Court could hear the controversy. And that's where we're at now. There is a split as to whether or not this health care reform law is an appropriate exercise of Congress's power under the Commerce Act.
And tell us, for our viewers, what is the Commerce Act generally?
Or the Commerce Clause,
Well,
rather.
Commerce Clause,
Yes.
thank you. Yes.
The Commerce Clause is under Article 1 of the United States Constitution, and it gives Congress the power to regulate commerce, economic activity between the states. And they've exercised that power within other industries previously in the past. With health care, the argument is under the Commerce Clause, the government's position is that this is a very unique market, that there's no other market like health care. Individuals cannot opt out of this market as they can with others. And the rationale to that argument is that anyone can be susceptible to a sudden illness, and therefore you're part of that healthcare market. The other issue is hospitals have to provide care whether or not they're compensated. And then the third element to that is that the uncompensated care is then cost shifted to other parties. So that is the argument essentially, and quite simply put, why it's such a unique market and different than transportation, different than food, different than rail, different than other industries we've had. The circuits are split in that they, one being the central decision in Florida, Judge Vinson has indicated that it's not a unique market and that it is not historically, when commerce has been regulated by Congress, there's always been an action or an activity by an individual. In this instance, the not doing of something, the not purchasing of insurance, in his view, is not an activity. Then we have other federal district courts that have held in Virginia and also in Wisconsin that feel the decision not to purchase health care on the state insurance exchange is in fact an economic activity because it's a mental activity, it's an economic decision. And those are just the two different perspectives. Yeah. And
do you know of the 20-some states how many courts have taken the view that the Commerce Clause reaches and how many approximately haven't, or is it pretty much split?
It's evenly split thus far.
So where's all this going next? Now we've got the split. Tell the viewers what to expect next and what likely timetable can they expect?
Well, there was the hope that our U.S. Supreme Court would hear it before their session ended early this summer, but that's not going to happen. The Supreme Court has made that clear. Justice Ginsburg has recently indicated that the appropriate place is for the federal district courts and their appeal courts to hear this issue, and that the Supreme Court, they weigh in historically very heavily on what the federal courts do before they take the case. So I don't predict at a minimum it'll be 2012 if they hear the case.
So definitely it's going to go up to eventually the U.S. Supreme Court, yes. And it looks like there's just a lot more waiting and patience we're going to have before the ultimate court decides this.
Right.
Pretty exciting. A lot's at stake here.
There is a lot.
Well, thank you both for giving us some enlightenment here, and let's stay tuned. Let's see what happens in the next chapter of all of this.
Thank
we
you.
appreciate your contribution. Thanks so much.